Imagine you spent 2 years planning the biggest event your company has ever been part of. Millions of dollars committed, contracts signed, staff hired, flights booked, equipment shipped halfway around the world. Then one morning you wake up, check the news, and missiles are falling from the sky. Your revenue is gone, and every contract you signed, still legally binding. That's not a hypothetical. That just happened to Formula One. Formula One officially confirmed that both the Bahrain Grand Prix and the Saudi Arabian Grand Prix are canceled for the 2026 season. Iranian missiles and drones are striking Gulf cities. The conflict between the United States, Israel, and Iran has turned the entire region into an active war zone. The Jeddah circuit, where hundreds of thousands of fans were supposed to pack the grandstands, done. The Bahrain International Circuit, where teams were supposed to be setting up right now, empty. Over $100 million in hosting fees, gone in an instant. The 2026 season drops from 24 races to 22, a 5-week hole blown into the calendar. All right, and here's the part no one's talking about. What happens to all those contracts? It's a question I deal with every single week as a Florida business attorney. And what's happening in F1 right now is a masterclass in why the answer matters. Think about what goes into a single Formula One Grand Prix. You've got the hosting agreement between Formula One management and the national promoter. Saudi Arabia pays an estimated $55 million a year just for the right to host. Bahrain pays around $50 million also. Then later on, the team sponsorship deals tied to an on-track appearances, the broadcast commitments, the corporate hospitality packages, the vendor contracts for transporting hundreds of tons of equipment by sea and air, the catering, the security, the temporary grandstand construction, the hotel blocks, the local businesses that staffed up and stocked up for race weekend. I think you get it. A lot of money went into this. Every single one of those is a signed contract with obligations, deadlines, and penalties. So when a war cancels everything overnight, who pays? Who's protected? And who's left holding the bag? And here's the question that should keep every Florida business owner up at night. If this happened to you, would your contracts protect you, or would they bury you? The answer comes down to two French words: force majeure. Let's go deeper on this, because this just isn't an F1 story. This is your story if you own a Florida business. Force majeure means superior force. In contract law, it's a clause that excuses one or both parties from performing their obligations when extraordinary, unforeseeable events make performance impossible, impracticable, or inadvisable. War, natural disasters, pandemics, terrorist attacks, government orders, events that no reasonable person could have prevented or predicted. In Formula One's case, industry analysts have confirmed that the hosting agreement between Bahrain and Saudi Arabia include force majeure provisions. Those clauses are what will reduce or defer the massive payment obligations now that a literal war has made the races impossible. And this isn't the first time. During COVID, F1 canceled and rescheduled races worldwide. Force majeure clauses were triggered across the entire sport. And in some cases, extra years were added to hosting contracts to compensate for missed events. That same playbook is in motion right now. The F1 CEO called it difficult but a necessary decision. The FIA's president emphasized safety above all else. But behind the press conferences, armies of lawyers on every side are pulling their contracts right now and turning to the force majeure section. That section is the difference between absorbing a manageable disruption and facing financial catastrophe. So let's accept the reality. Force majeure clauses aren't legal fine print. They're the single most important safety net in your business contract. And if you're in Florida, you need to understand exactly how they work, because your turn is coming. Here's where it gets complicated, and where most Florida business owners are dangerously exposed. A force majeure clause only protects you if two things are true. First, the clause actually has to exist in your contract. You'd be shocked how many business owners assume they're protected and have never checked. And second, the specific event that disrupted your business has to be covered by the language of the clause. And this is where Florida law creates a real problem. Florida courts construe force majeure clauses narrowly. That's a key case from 2019 where a federal court in the Southern District of Florida ruled that these clauses should be limited in their application to exactly what the language supports. That means if your clause says hurricanes, earthquakes, and fires, a judge is not going to extend that to cover a pandemic, a supply chain meltdown, or a government shutdown order. If the event isn't named, you're not protected. Now think about what Florida business owners face. This is the most hurricane-prone state in the entire country. Hurricane Ian in 2022, Hurricane Idalia in 2023, Hurricane Milton just last year. Every one of those storms shut down businesses, delayed contracts, wrecked supply chains, and made it physically impossible for people to fulfill their contracts. And then there was COVID, which shut down entire industries for months. But here's the hurdle most people don't see coming. Even if you have a force majeure clause, even if it names the right events, it can still fail you. If the clause doesn't define what exactly happens when it's triggered, does performance get suspended, delayed, excused entirely? Who bears the cost? Then you're headed for a courtroom fight with no clear answer. If the clause doesn't require timely written notice, the other side can argue that you waived your rights. If it doesn't include a mitigation obligation, a court can rule you didn't do enough to minimize the damage. And if your contract has no force majeure clause at all, well, Florida law offers only limited backup. There's the doctrine of impossibility, but you have to prove performance was truly impossible, not just difficult or expensive. There's the frustration of purpose doctrine, which Florida does recognize, but it does require showing that the entire purpose of the contract was destroyed, not just disrupted. Formula One has billion-dollar legal teams drafting these clauses with precision. The sponsors, the promoters, the broadcasters, they all have sophisticated force majeure language tailored to their exact risk profiles. That's why even though cancellation is a financial blow, it's a manageable one. The clauses are doing their job. Most Florida small and mid-sized business owners, they're running on boilerplate language somebody pulled off the internet 3 years ago, or worse, they have nothing at all. So here's exactly what you need to do. First, review every active contract you have: vendor agreements, client contracts, leases, partnership agreements, service contracts. Find the force majeure clause. If there isn't one, that's your number one priority. You also want to make the language comprehensive. A strong force majeure clause in Florida should specifically name hurricanes, tropical storms, flooding, pandemics, epidemics, acts of war, terrorism, civil unrest, government orders, and supply chain disruptions. And then, this is critical, include a catch-all phrase like, or any other event beyond the reasonable control of the parties. Florida courts have recognized these catch-all clauses in contracts. In one case, a court found that excessive rain qualified under an any other condition provision, excusing delayed home construction. In another, a government denial of a permit was held to be a qualifying force majeure event. You want specificity and breadth working together. You also want to define exactly what happens when the clause is triggered. Does performance get suspended for a defined period? Is it excused entirely after a certain number of days? Does the contract terminate? Who absorbs sunk costs? Look at how F1 handled it. Their contracts included provisions that may reduce or defer hosting payments, but also potentially extend the contract term to make up for missed events. Your clause needs that same level of clarity. Include a notice requirement. The affected party should be required to provide written notice within 5 to 10 business days of the force majeure event, along with documentation of how the event actually prevents performance. And also another thing, add a mitigation obligation. The clause should require both parties to take reasonable steps to minimize the impact. Florida courts look for this. If you sat on your hands when you could have done something to reduce the damages, your defense crumbles. And above all, work with a Florida business attorney who understands how these clauses get interpreted in this state. The FAR real estate contracts that are standard across Florida already include a force majeure clause, covering natural disasters, terrorism, civil unrest, with specific provisions for extending closing dates up to 7 days and termination rights after 30 days. That's the level of specificity your business contract needs. Not a generic paragraph, a clause built for Florida, for your industry, for your risks that you actually face. Look, Formula One is the biggest motorsport on earth, billion-dollar organization, global brands, armies of the most expensive lawyers in the world. And when war erupted in the Middle East and erased 2 marquee races from the calendar, over $100 million in revenue, vanishing in a single announcement. What saved them from a total financial disaster? 2 words buried in their contract: force majeure. Now here's the part that should hit home. You live in Florida, a state where a Category 4 hurricane can form in the Gulf of Mexico and be sitting on top of your business in 48 hours. A state where a pandemic shut down your entire industry with 0 warning. A state where rising seas, international supply chain chaos, and regulatory shifts can upend your business model in ways you have never imagined. Formula One was ready. They had the clause. They had the language. They had the protection. Are you protected? Because the next hurricane isn't going to wait for you to call your lawyer. The next crisis isn't going to politely check whether your contracts have the right language. It's going to hit. And in that moment, you're either protected or you're exposed. The time to put a force majeure clause in your contract is before the disaster, not after, not during, before. Now, if this video opened your eyes, hit that subscribe button. I make content that helps Florida business owners protect what they built. And drop a comment and tell me, does your business have a force majeure clause right now? I generally want to know. And if you know another business owner in Florida who's running without this protection, send them this video. It might be the most important thing you do for them this year. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.